Welcome back. This is Naidu from Techno Legal Forum. Let's continue from where we left. We are going to talk about section 24, that is transfer of personal data outside India. Okay. So in other words, the data protection is enforceable for the data which is going outside. Okay, so we'll see how exactly. It's not only for data protection, DPDP Act is not only for these, Act is applicable for the, applicable to India. It goes beyond. On what situations we'll see. Personal data of the data principal, that's Indian, outside India. Personal data of the data principal is a Indian. If it is going outside, subject to conditions prescribed by the central government. So if the foreign company, if Indian citizens are availing the services of a foreign company, okay, that company is under the lens of DPDP Act. That's the meaning of it. So our data principal will avail the services from a data fiduciary. That data fiduciary is US based. Let's say example. That company comes under DPDP Act provisions. That's first understanding we should have. Next, what is this? Blacklist. India follows blacklist, or it is also called negative list. Why it is called? Let's say India, can transfer the personal data, personal information outside of India. Okay, except list of countries notified by the government of India. So those countries which are there in the list, that is nothing but your negative list or the blocking list, or blacklisted. Except those countries in that list, rest of the countries the data can flow back and forth. So it is a business friendly, isn't it? It's a business friendly act, I could say, because India has to really keep doing business with outside world to a large extent. Then if you have to really keep this compliances burden on those companies which are dealing, then it becomes a little obstruction. So it is so Indian list is also called business friendly. It promotes good business, isn't it? Because companies don't want to really don't want to burden with the too much compliances. In comparison, GDPR, General Data Protection Regulation, that is the European the data protection law were followed by all the countries under Europe, I think around 27 countries. They follow something called adequate I think it is something they follow for every country the data moves, that country should already validated by the pre-validated by the GDPR. Every country, the data moving from that European countries to other countries, each of those countries already valid, each and every individual countries will be verified or adequate decisions have been taken. For only those countries the data flows, means it's already determination was made. And for other countries additional beyond that also will be considered, apart from the predetermined list of countries which the GDPR already union that European Union already agreed to with it, data will flow to them. And those countries which are not there predetermined, they have to follow additional responsibilities. Quite different from Indian list. We call that as a white list. So every country the data has to flow, that country should be there in that list. India's it's not like that. Every country can keep sending the data, but only countries which it cannot send should be only listed in that list. That's why it's called negative list. So that's why it says India is a more business friendly. Probably these things will further scrutinized as the implementation of this act is in full force. See, one reason I told Azure is from Microsoft, Google Cloud, AWS, Amazon. See, we Indian companies use. So we don't have our own kind of Google or Azure or things, right? So we use all these services from US and European Union. So when we're using that, our data has to go and get saved in those clouds infrastructure built by this US and European companies. So in that sense, even data centers, predominant data centers are there where these cloud infrastructures are built. Data has to move there. So if we put the similar provisions as GDPR, it will be a too much compliance requirements that each and every company has to, and it will indirectly affects the business growth. So for that reason, so government of India will decide which country should be blacklisted. That country will be put it in that list, and India will not be able to send the personal information to that country. So as we speak, most of our data is in fact sitting outside. Let's move to the next exemptions. So exemptions is a very important chapter. From the point, exemptions means DPDP Act, the entire act is not applicable as decided by the government. Okay, so there are situations where this need to be done. We'll see those situations. State exemptions and research. State exemptions means like state instrumentalities. State instrumentalities means agencies under direct control of government of India, right? Like research, raw instrument, research and analysis wing, CBI, enforcement directorate, so many other institutions right? So state exemption. Let's see. So, as you see, this heading is very important. Some of the entries are completely outside the scope of DPDP Act, as if there is no DPDP for those companies. Which are those entities which deals with national security, sovereignty. So, we'll come to the examples. National security and sovereignty. Then other is judicial proceedings, court related matters, right? Research, statute, for example, census, statistical institutions, national statistical institution of India, they collect the data from the citizens for the generating census for that year. So even those institutions, because they collect the personal information, basically they collect very too much information. So if we expect them to follow DPDP provisions, it becomes impractical for their work. However, there are certain features they are implementing while collecting, that anonymization means the names will be at the when they are generating the outcome of the census to the public, they will not provide the statistical information, means they will not provide the specific names. They say that these many number of people are under poverty, right? They will not mention the specific information. So that is very much in compliance, right? You are not revealing the specific details or the personal information. A personal information is that one which identifies a person. As long as you take care of non-identification of a person by looking at the data, that is fine. So that kind of things. So this organization which comes and do this kind of research and statistical analysis, which is required for our governance, they are exempted from the DPDP. Judicial process and national security examples, if I have to give, research, right, like foreign FBI and all, we have research and analysis wing, RA. So they deal with the suspected persons. Potentially they going to cause harm to national security and sovereignty. So they have to track them. Tracking means every aspect of personal information. So if you impose DP on them, obviously they cannot able to do all that, right? So it's as good as you can't take consent from a criminal, right, to take his information. So this aspects, those institutions will be exempted from DPDP Act itself, the entire Act itself. So here it's mentioned about one aspect here. Okay, this we know, integrity of India, foreign relationship. What exactly it means? So when we have diplomatic relations with so many countries, the delegates of this country, diplomats of this country, have to share their government has to share their personal information with other countries. Similarly, those countries will do similar way, right? So in this aspect also, you can't impose, you cannot expect the government to take consent, which is a consent is a very important obligation under DPDP, right? So diplomats information will be sent to another other countries by the government of India without consent, right? So that's why these are the reasons. Even police authority, to maintain public order, prevention and crime also, they will identify certain you know, elements in the society, and they keep a track of their telephone calls, complete surveillance, biometric mapping, everything they have to do in for the for the purpose of public order, prevention or incitement of any cognizable offences. For all these reasons, the agencies which do these activities obviously have to be exempted from DPDP Act. Otherwise, they are unable to perform their functions. Okay, I think you got the real reasons why certain agencies, or we call it as generally instrumentalities of the government. All these agencies are called instrumentalities of the government. Judicial and legal as well, you know that, right? Even all the proceedings, evidence, everything has to be collected. It might involve the personal information also. Otherwise, the proceedings cannot be performed by the courts. So these are exempt. Research, best example I gave is the census or statistical Institute of India, Society of India. They keep their job is to keep collecting statistics of the population, various parameters. That data will fed to the government. To based on that data only, the government will form the welfare policies. So in order to collect those statistics, that institution and its employees are exempted from DPDP. Otherwise, it will, the welfare growth, welfare of the country will be impacted. That's the reason. So this is if government is trying to include so many other institutions under section 25, then definitely an alarm will rise, right? It actually hits the privacy. So so they should be monitored. This kind of exemptions list should be monitored. Okay, let's move to the next slide. Okay, startup and special exemptions. Okay, so many of you know, right? Startups, India has, as I think, as we speak, like third or fourth largest startups in the entire world. Startups are a business or innovative way of doing business by small companies, even single person or group of person got together, they invent something which solve the real problems of the society, whether it is technical or any aspect, discoveries, inventions. The small companies, that number of companies has grown to such an extent. There is also startup and small business. So see, these businesses are, we can also call in generally data fiduciaries. So they're exempted from some of the provisions or all the provisions. Okay, the reason I will explain in a bit. So because first of all, they are small companies, their volumes of dealing with personnel is also less. They pose very low risk, hence they are exempted. Exempted from certain obligations, like first of all, they are small companies, they have small investments to begin with. So if we impose them to appoint a grievance officer requirement and expect them to do audits and data protection impact analysis, this as additional expenses to those small business and startups, which in fact will discourage or demotivate from people coming up and starting startups, or developing services and products for the country. That will in turn affects the country as a whole. So in order to encourage small startups growth, the additional burden as imposed under DPDP, government thought it's early development of our startups. So let's dilute as many obligations as necessary for those companies for the growth of small business and startups. So similarly, academic research, all this will contribute to the overall development. So even those will be, they don't have to follow the entire provisions under DPDP. They also may follow minimum reduced compliance obligations. And also for healthcare, right, to deal with medical emergencies, privacy, small health units, if they have to do their work, you can't impose those organization, which in generally, as I keep mentioning, fiduciaries or data fiduciaries. So to balancing medical urgency with privacy rights. So certain exemptions are necessary for those reasons listed. Okay. So let's. This is the last slide, the last chapter on for today. Penalties under DPDP. It's a very short one. So as we already know, the maximum is 250 crores. So this imposition by the Data Protection of Board done against the data fiduciary if they fail to have adequate data security safeguards. So what are the personal information they are gathering? If they fail to provide the safeguards, that could be one reason. And other reason, right, misuse of the act by the data principal, the citizens, by filing false complaints will lead for 10,000. Maximum for this, one is obligations by the obligation failure of the data fiduciaries to fulfill the obligation of the act, and other reasons are data breaches, data leakages of the data fiduciary will have those penalties. So you don't see anything criminal like imprisonment and all. The Data Protection, Personal Data Protection Act is more of a civil penalties, no criminal. Yeah, this here the clearly breakup is given on so we have to go back and check these sections for quick recaps. So this is the maximum penalty if you fail to notify. When the breach happens, the first responsibility we have seen, right, the data fiduciary should inform the board. Parallelly, it should inform every data principals whose data has been breached. Failure to do 200 crores. See this children data, non-compliance with the obligations of children data, it will lead to 200 crores. and we already studied about significant data fiduciaries. If they fail to appoint DPO or conduct independent audit or do a data impact analysis, right, risk assessment and all, if they do fail to do all that, 150 crores. So, and other non-compliance from the board has decided some complaint, and it has given orders, and provisions act are not non-compliance for those by the data fiduciary. The penalty is 50 crores. So this one we already know. 10,000 by for breach of duties by the data principals. So the board it takes into consideration, after looking into the aspect of the non-compliance or the breach, it look at the nature, duration of breach, affected, repetitive nature. So all these things will decide on the this aspect, the penalty. Okay, there's one before we move on to the next one. There's one more aspect I forgot to mention. Okay, in this we talked about data transfer outside India, right? So one important aspect we have to remember here is DPDP Act provides, right, data transfer through that list of blacklist and all. It is like a these data transfer restrictions. Data transfer, we can say restrictions are like are in addition to data. DPDP already have data transfer restrictions, right, as we saw that. These restrictions is in addition to companies, for example RBI. RBI is regulatory body for banks, right? Banks will deal with financial matters. And personal information also, right? So all banks which are under RBI has its own rules, right, with regard to transfer of financial information to other countries, right? We have payment companies, right? So they have their own guidelines or restrictions also to follow. Number one. Number two, SEBI, equities and the share market, Security Exchange Board of India. It is also a regulatory body, right? It will have its own restrictions. The restrictions of this body is on top of DPDP Act restrictions. So in other words, what it says is, if the restrictions of the DPDP are floors of a building, The restrictions of the regulatory bodies are like ceilings. In other words, DPDP is not the ultimatum. The ultimatum is a combination of the restrictions for the data transfer with regard to RBI guidelines with regard to payments and data transfer, and SEBI also. So they have their own guidelines. That guidelines will act in addition to DPDP provisions. So it is not the DPDP is not the ultimate regulatory in terms of sensitive information crossing the borders. So that we should keep in mind. It's very important point. Okay. So with that we have come to the section 26, I believe. Yes. Startup and penalties. These are the schedules anyway. It's not. So 27 I will start. Then at the end I will take up the on account of DPDP. What other acts which are already in existence? For example, right to information. Okay. Right to Information Act passed in 2005 and IT Act passed 2000. So they have certain provisions. How that provisions are also modified in order to be aligned with the DPDP. So those things we'll study at the end of the end of this sections we are studying from the DP. So next we are going to study from 27, section 27. Then we'll move on. We'll come to the last section, that is section 44. That is an important aspect of DPDP Act, because there is a conflict with regard to DPDP. DPDP talks about data privacy. RTA talks about transparency. So how it is balanced? So both is required. Only one entire prominence should not be given to the data privacy, or entire prominence should not given to the RTI, which is transparency. So the balance should be struck. So that is how we are going to understand what are the modifications done, and there were some court cases which have filed due to the this conflict. So we will understand those aspects also. So thanks for joining this call, and have a good rest of the day. See you then. Bye.